Last week, New York's Department of Financial Services brought its first cybersecurity enforcement action. This is huge news for banks and fintech companies and insurance companies that are regulated in New York State. Because back in 2017, New York put out this regulation that governs cybersecurity, and it was widely viewed as one of the strictest in the entire United States. In fact, a lot of banks claimed that it was literally impossible to comply with this new regulation. So the Department of Financial Services gave everyone a few years to get their cybersecurity programs up to snuff, and now time's up. So the Department of Financial Services is now seeking to impose penalties on banks and fintechs and insurance companies that don't have a good enough cybersecurity program. So banks are scared that they might be next. And today I'm going to talk about that. I'm going to talk about the enforcement action that the Department of Financial Services brought last week and what banks and fintechs and insurance companies can learn from that about how the Department of Financial Services is going to be enforcing its cybersecurity regulation. New York's Department of Financial Services, or DFS, claims that there was a vulnerability in First American's cybersecurity program that resulted in the exposure of account information for millions of accounts over a period of years. They also say that First American's response to learning of the exposure back in December 2018 was inadequate and, in fact, failed to comply with its own policies. And they make a number of specific claims about how the cybersecurity program was inadequate. First, they say that the testing that was done failed to comply with their own policy, which is part of why the identification of the exposure didn't occur as early as it should have. Second, they say that once the exposure was identified, the response failed to comply with the time frame requirement of First American's policy. They also say that once the exposure was identified, the testing was inadequate to identify the extent of the exposure. So out of millions of accounts, only 10 were tested, which slowed down the identification of the extent of the exposure. They also say that when the cybersecurity program recommendation came up to management, management ended up not following the recommendation of the cybersecurity program about how best to respond to the vulnerability and how best to protect customer information. First American is fighting the DFS. In most cases, the DFS is able to extract a penalty from a regulated entity without having to actually prove that its charges were justified. But in this case, First American is going to force the Department of Financial Services to prove its case in court. And First American thinks it has a really strong case. One reason for this is that another regulator in Nebraska already looked at the incident and looked at First American's response and determined that it was adequate. And so First American argues, well, if Nebraska's right, then New York must be wrong. And we're going to find out soon who's right and who's wrong, because the hearing in this matter is scheduled for this October. This case shows that the Department of Financial Services is ready to aggressively enforce its cybersecurity regulation. And this should be very concerning to regulated financial institutions and insurance companies and fintech companies, because anyone in cybersecurity will tell you there is a lot of subjectivity in evaluating whether or not a cybersecurity program is adequate. And unfortunately, often this is evaluated after the fact with 20/20 hindsight. And it's difficult for a company to say we had a great cybersecurity program after there's been an exposure of its customers' data, because obviously the program wasn't good enough to protect its customers' data. But that's not really fair. Everyone gets hacked. Even the Department of Defense gets hacked. So a lot of banks and fintech companies are saying, what's a poor financial services company to do? The DFS's allegations against First American underscore a number of things that financial services companies can do now to avoid facing a penalty down the line for having an inadequate cybersecurity program. First of all, if you spend a bunch of money developing a great cybersecurity policy, comply with your own policy. Second, and this is almost as important, document that you complied with your own policy, because you don't want to be in a situation where the DFS comes knocking on your door, asks how you complied with your policy 3 years ago, and you have to say, well, the person who was responsible for that is no longer with the company, and we don't have anybody else who knows how we were complying with our own program. So document it and keep those documents. Similarly, when in the heat of a crisis, you're getting multiple recommendations about what you should do, document those recommendations and why you chose one over another. Because regulators love to come in after the fact and say, we found somebody at the company who had a recommendation that was very similar to what we as regulators think should have happened. And by refusing to do that, you broke the law. So you want to document why you chose one response instead of another, so that if you ever have to defend it, you'll have some ammunition that you can use. But even if you do all those things, you still are going to potentially be at risk because there's a lot of ambiguity around this regulation. And so far, there's just not a lot of law in terms of judicial interpretations about how the DFS can enforce its own regulation. So you could be in a tough situation, but good news, I'm a lawyer. So if you have questions about your cybersecurity program or what you can do to avoid an enforcement action, or if you think there may be an enforcement action coming, give me a call. I'd love to talk to you.